estate planning, beneficiary designations that work. Welcome to Tea at Taxevity, where you get insights from insiders, our many clients and friends. I'm Pramod Sharma, your actuary at Taxevity. I help people who care about sustainable financial independence harness the power of life and health insurance. Our guest is Kathryn Bennett. Kathryn, what do you do when you're not being interviewed?
Try to have a lot of fun. But more seriously, I'm a trust and estates lawyer by training, which I happen to think is a lot of fun. I work primarily with financial institutions, so I'm not in traditional private practice. So, yeah.
When it comes to estate planning, why don't I just have everything go into my estate and have the will decide where the assets go?
Wow. That's a question that has so many possible answers. The starting point would be that the majority of Canadians, unfortunately, don't have a will. So that governing document, leave it in my estate and let the will do everything. If they had a will, that would help. So the first thing would be, if you don't already have a will, you probably should.
Okay.
Next point, certain types of assets, if they go in, any asset that's in your estate is subject to probate, which is the process by which the estates court says this person, your estate trustee in Ontario, executor in other provinces, liquidator in Quebec, has the legal authority to deal with all of your assets and pay debts and taxes and distribute those assets. If it goes into the estate, however, did you note that debts and taxes part? Yeah, okay. Things that go into the estate. So say your life insurance goes, you designate your estate as the beneficiary. It's exposed to your creditors. So money that you might have thought for life insurance, a lot of people buy it to provide for their family if they die too soon, die prematurely, or to make sure that the tax bill can be paid, capital gains tax on a cottage, for example. If the money goes into the estate and it goes to pay creditors and taxes and other liabilities, that money may not ultimately end up where you want it to go, especially if you don't have a will. In addition, the cost of probate in Ontario, second highest in Canada, Nova Scotia's first, British Columbia is third, is $5 per thousand for the first $50,000 of value, and it's $15 per thousand for everything over that for the estate administration tax, and there's no cap. So if it's $1 million of life insurance that goes into your estate, it's the first million, it's $14,500.
Okay, that doesn't have to be
That
paid.
doesn't have to be paid
Okay.
if you do strategic beneficiary designation planning. You take a little bit of time to sit and work with a qualified insurance advisor who can give you some recommendations. Also work with a qualified trust and estates lawyer who understands about insurance planning. Not all of them do, so you may want to ask about that, particularly if you own life insurance and you want to make sure that it goes outside the estate. You want to do some strategic planning. Another reason that you may not want everything to go into the estate is, for example, RSPs and RIFs, so registered money. If it goes to certain beneficiaries that qualify for a rollover, deferring the tax when you pass away, you can defer tax. Well, if it goes into the estate, those people are not automatically beneficiaries under your estate, especially if you don't have a will. So again, you're paying probate costs, time, exposing it to creditors, when with a beneficiary designation, those assets could flow outside the estate and you'd get your tax relief, and that just becomes much simpler. So your estate plan is actually simpler when you do some proactive beneficiary designation planning. So in my experience, it's a rare estate where the good plan or the best plan involves putting personally owned life insurance, RSPs, RIFs, tax-free savings accounts into the estate. It's a rare estate where that makes sense.
Okay, where can we use beneficiary designations to bypass the estate?
We start with life insurance products. So that would be life insurance, but it's also segregated funds, which are investment products issued by a life insurance company. They run the spectrum between mimicking a GIC through to mimicking mutual funds, for example. And you can do beneficiary designations for all of those products.
Mm-hmm.
It's under the Insurance Act. So the reason you want to work with a qualified insurance advisor or a trust and estates lawyer who understands the insurance rules is the rules aren't as simple as simply saying, hey, I want this person to get them. So if you have assets, life insurance that's a cash value product, RSPs, you want to protect the value inside that product during your lifetime from creditors. Under the insurance rules, in all of the provinces except Quebec, because Quebec the rules are a little different, if the beneficiary is your spouse, meaning legally married spouse, or your common law spouse with whom you've lived for 3 years or more in Ontario, your parents, your children or your grandchildren. So you are the person the life is insured. If it's someone in that category, that's called the family class. You get lifetime creditor protection. So simply by being able to designate those people as the beneficiary of those life insurance related products, you get lifetime creditor protection. But you need to talk with someone who understands those rules so that you get the right advice to make sure that your people qualify. If your common law spouse, for example, you've only been living together for 2 years, not 3, they don't actually qualify. And even after the 3 years passes, they still don't qualify. You'd actually have to go back and redo the beneficiary designation. This is where it gets tricky and complicated, which is why the advice of those qualified professionals really helps. So insurance products, you can also do an irrevocable beneficiary designation. Irrevocable because it's English and we can pronounce it more than one way. But when you do an irrevocable designation, you give up the ability to deal with your policy as easily as you normally would. So again, you want advice from a qualified advisor before you do something like that.
Can you give us an example of where someone might want a beneficiary to be irrevocable?
I could, if I could actually really think of one. And the reason I say that is simply, in all the years I've been doing this stuff and doing this kind of planning, I found very, very few cases where an irrevocable beneficiary makes sense.
Aren't there situations, say in a divorce, where it would make sense? Or are there other solutions there?
There are other solutions that involve a bit of planning. In a divorce, the reason the spouse who's, say, getting spousal or child support might want an irrevocable designation is so that the person who's paying support can't go and change the designation. The challenge with it is if you don't plan it correctly, and this is the family lawyer who's now going to have to work with the insurance advisor to do this, you might end up with a windfall. So say it's a $250,000 life insurance policy. The former spouse is the irrevocable beneficiary. The child support obligation ends on May 1st of 2015. And it's an irrevocable designation. So now I, as the policy owner, the person who is insured, I cannot change the designation without my former spouse's written consent. I can't get the written consent, and I die in July, 2 months after the child support obligation has ended. That spouse gets a windfall of $250,000.
Right. Okay.
So it sounds like a good reason to do it, but if you've actually ever dealt with an estate where someone did in fact die, or the support obligation period has ended and the person who's the irrevocable beneficiary won't consent to the change, it gets really difficult. So my view is it's a pretty rare case in where it's spousal and child support. There are other planning alternatives where you can deal with that. So irrevocable, probably not a good idea, but you can appoint a trustee to receive proceeds for a beneficiary. And that's the part where you combine these things. So life insurance beneficiary designation planning, as you can see, it can get a little bit complicated. It has to be done in writing. We can't do videotape. It has to be in writing.
Okay.
It can be on the insurance company form, which will be the very simple, straightforward ones. You can do it in your will. The downside of that, assuming you have a will, is that a probated will is a public document. Do you really want your beneficiary designation planning in a public document? So the third choice is a standalone separate document that does the designation. Again, typically those are done with the assistance of a qualified trust and estates lawyer who understands the insurance beneficiary planning rules and can help you set up that
so
structure.
beneficiary designations are important for life insurance and segregated funds. Are there other places they can be used?
Banks and trust companies also issue registered products. The rules there are different. You do not get, there's no opportunity for lifetime creditor protection, even though you've designated the same people that would fall in the family class if it were issued by an insurance company.
Okay.
So you don't get lifetime creditor protection. So if that's an issue, then you need to decide which type of RSP or RIF registered product do I want. Life insurance company issued or bank or trust company issued. When you do your beneficiary designation for those products, it does flow outside the estate. However, this is the caveat, the way the law in Ontario is written, the Succession Law Reform Act, it doesn't say crystal clear that it flows outside the estate for all purposes, which might include the value for estate administration tax. So it would go to the beneficiary, but it might be subject to estate administration tax. We don't have any case law on that one. So that one's kind of a gray area that is evolving. Will there be litigation at some point? Probably, because it'll be $1 million RRSP or RIF, and someone will ultimately litigate it. So beneficiary designation planning is part of a good comprehensive estate plan. It can complement your will planning. It complements business owner succession planning. It's, I think, an integral part of it. Does everybody need to do the planning? Well, I think if you've got any kind of a product where you could do a beneficiary designation, including your group insurance through work, I think you need to sit down and work with a qualified practitioner, an insurance advisor, a lawyer, an accountant. Some financial advisors and accountants understand the nuances, but typically it'll be a qualified insurance advisor, or if you're doing more complicated stuff, a trust and estates lawyer.
That sounds like your key message. What's the best way for people to reach you?
Through LinkedIn. That's the easiest and simplest way to reach me.
Thanks very much for dropping by.
Thanks, Pramod. Take care.
Thanks for joining us for Tea at Taxevity. The Taxevity Insurance Advisory helps you understand insurance and bridges gaps in your coverage. There's no premium for peace of mind. How healthy is your insurance?